Ready for us, Judge?
I am. Do you need any more than 5 minutes for rebuttal?
I think 5 minutes will do, Your Honor. Good morning. I'm Roy Wasson, counsel for the appellant. In this appeal from the adjudication of criminal contempt, indirect criminal contempt of court of my client, an 82-year-old trial lawyer who's been practicing for
Counsel, I'm just going to interrupt you just a second. I apologize. This is the KARL KOEPKE and Nancy KOEPKE case. Yep. I just didn't say that for the record. All right, continue.
Two main reasons why the contempt adjudication must be reversed, and the first one is just black and white. Every district court of appeal of Florida that has addressed the issue has held that it is fundamental error to adjudicate a defendant in criminal contempt of court without personal service of process of the order to show cause.
Now, counsel, can you point to the case that says personal service of process is necessary as a fundamental error issue?
Absolutely.
Because I've read the cases, and I do see there's some varying degrees of service there, but it seems like in all those cases it was raised at the trial court.
I'm sorry, it was what?
It was either raised at the trial court level.
Oh, not at all.
Or they didn't appear at all. But so I want to know exactly what case you say where it's fundamental error to not have personal service of process.
Well, yes, I have here the first district case in Transport and General Insurance Company versus receivership, cited on page 38 and 39 of our brief. All right, that was a case where there was service by certified mail, which is more formal and better than the fax or email service here. And the court held that the appellant correctly asserts that the insufficiency of service of process mandates the appellant's motion to dismiss the amended order to show cause should have been granted. All right, the fact that personal service was not for, it says it's fundamental error.
But wasn't there a motion to dismiss at the lower court in that case?
I'm sorry, which case?
I stand corrected, there was, but the case
Transport.
Cited before that, the Giles case, which cites to the Transport and General case, and that's cited on the middle of page 38 of our brief. It says, there's no evidence to establish that Giles was served with the second order to show cause. Giles was entitled to have the order served upon him, not sent facsimile to his attorney, served by service like by email or by fax, service of something beyond the initial pleading of the case. It says failure to comply with Rule 3.840 constitutes fundamental error. That means you can raise it for the first time on appeal.
But in Giles, they brought it up below, too.
I didn't hear you, Judge.
In Giles, they brought it up below. The defense attorney argued they were not prepared for a hearing. They were not ready to go forward. They didn't even really understand the facts of the case because that wasn't in the order to show cause.
Well, I don't know if I don't know why the court would have said it's fundamental error if it had been raised and preserved as an argument at the trial court level. They wouldn't have needed to say that it was fundamental error.
The rule itself only says service, correct? Not service of process, not personal service.
Correct, but you got to think, an order to show cause is the initial pleading it's the initial charging document in a new action. It's an action within an action, so it's like a summons and a complaint. It's something that initiates that collateral action within the case. It has to be served.
But the
Transport doesn't say what does not address the fundamental error. So if that's the best case you've got, you better come up with something different.
I heard you say it didn't address it, but then I didn't hear the last part.
If that's the best case you have for that proposition, you might want to come up with something different than Transport, because that does not address the issue of fundamental error. It was preserved. It was raised. And Transport didn't address that issue at all. So what's your best case for the concept that it's fundamental error?
Well, the Graham case says that failure to follow the dictates of Rule 3.840 governing indirect criminal contempt constitutes fundamental reversible error, and the issue there was the sufficiency of the service of the order to show cause. He must have got the order to show cause because he filed a response to it. Motion to dismiss, I don't know, the motion to dismiss I don't think was based upon the lack of service. In that case, you can respond to something and file a motion to dismiss, but unless the issue was raised that service was invalid, there would have been no need for the court to talk about fundamental error. So the fact that the court says it was fundamental error means that the issue wasn't raised at the trial court level. So that's my business.
Your client, though, was counsel of record, correct?
He was, but still being counsel of record in a case doesn't get the initial pleading. If, the Rule 2.516 on how to serve counsel of record with motions and orders and notices, that's once the case has got going. And if I was counsel of record for somebody and they served me by email or by fax with a complaint and a summons, even if I'm counsel of record for them, that's not going to initiate.
So is this a gotcha argument that they didn't check this box because your client was counsel of record, was served the same way everybody else is served in every case through e-filing? It shows up, is represented by counsel, is fully prepared, never makes any argument that he's prejudiced by this, and now for the first time says, gotcha, he wasn't personally served?
Well, I think the court understands my position on that argument, so I'll spend some time on the other argument, that is, that the movement here did not establish beyond a reasonable doubt the elements of criminal intent, that my client, a distinguished trial lawyer who's been trying cases for 50 years, had the criminal intent to violate this order and deceive the court. And
let me ask you this, that in the interim when this discovery dispute was going on, was your client able to take the funds from that settlement and put them in an irrevocable trust?
They're in a trust.
And that cannot be attached by the wife?
That's my understanding of the operation of a trust. It couldn't be attached by anybody.
I'm happy to hear how that's not a criminal mindset to divert these funds. No, the question was, you've got to get to the specific order in question. You can't just say because he did something that you don't think is a good thing that constitutes criminal contempt. You have to look at the order that was violated, allegedly, what the order required.
This is the exact type of conduct that we talk about at seminars in terms of professionalism, where someone is absolutely taking every means possible to try to comply with discovery and try to subvert the ends of justice in a case. This is the type of conduct that is really forcing these issues to the forefront. I mean, this is just a situation where your client did everything he could to hide the fact that he had received a $400,000 fee in a settlement of a case.
But at the time the discovery request and the orders were in question, no settlement had been consummated.
Let's talk about that argument. They go to mediation and they settle the case, policy limits. The only thing that doesn't occur after that is that there has to be court approval of certain aspects of where that money's going to go. But it doesn't change the fact that the insurance company has paid the $1 million settlement. The only issue is what's going to happen with some of that money. It's never going to change any of your client's fee in the case. Correct?
Well, no, the court, certainly in a minor settlement, the court has, and I've seen judges cut back attorneys' fees. You're not going to get 40% of this fee for just negotiating something by a few letters or something like this without hotly litigating it. No.
What did the order of the trial court say that he was to bring? Did it not say mediated settlement agreement? That was the title, correct?
I don't remember if it used the exact title of the settlement agreement. There was a reverse title. One was settlement agreement at mediation, and the order said something backwards, the mediated settlement agreement. And Mr. KOEPKE's lawyer hey, first, the defense lawyer in that case said that there was no settlement consummated, there was no release signed, no funds had been paid. That was the defense lawyer in the Williams case that was working towards settlement, and there was a motion to enforce, compel enforcement of the alleged settlement that the trial judge in the Williams case did not grant. If there was a settlement, the judge would have granted the motion to enforce the settlement. The fact that the judge didn't, there was, the
But
question.
was there a mediated settlement agreement?
Yes, but it was subject to conditions that it had to be approved by the court, had to be, a release would have to be negotiated and signed. The distribution of the funds, there was a question still from Mr. Caggiano, who represented my client at the trial court level, a question about the father, the father of the minor children's capacity to agree to this settlement. So it was.
Do you not see how the placement of these funds into a trust that can't be attached, how that looks in terms of the rest of the evidence in the case? You see that, don't you?
Judge, I will accede to that, but I got to go back to the law here that it must be conduct that clearly violates the order. Not just a trial court cannot make a finding of contempt for violation of court order based upon its intent in issuing the order when you can't just go back and say, you know what, this isn't right. You didn't do what a professional person should have done. You've got to look at the language, the specific language, and establish a violation beyond a reasonable doubt. There are half a dozen reasons why my client had a good faith belief. When lawyers are negotiating settlements, they have to use their language very clearly, because if they agree to something that the other side snaps on and says this is an enforceable settlement, and not all the T's are crossed and the I's are dotted.
The consummation of a negotiated settlement is a signed settlement agreement, correct?
An enforceable signed settlement agreement, it has to be more than that. With a juvenile case, it has to be approved by the court.
But
So
go ahead.
Is it your client's position that a signed mediated settlement agreement signed by the defendant is not a document evidencing a settlement of that claim?
It's a document evidencing a potential or a settlement, an inchoate settlement agreement, but it's not settled yet.
Does it depend on what the definition of the word is? I mean, because we're parsing language we're atomizing language right here. He had a signed settlement agreement that he hid and refused to produce at all costs. And the point of the trust, and I'm happy to hear this, the explanation, that evidences a criminal intent by putting that money into a trust that's non-attachable. So I'd like to hear your client's position against that.
Putting money into a trust to protect the bulk of the trust so that it could, of the funds, so that the children, the beneficiary, my client's clients, could have the benefit of the funds, so it wouldn't be tied up or encumbered. But
It's the attorney's fees we're talking about, not the settlement. It's the attorney's fees that were put into the trust, correct?
the whole thing has been put in a trust.
Right. The attorney's fees are what we're really talking about in this.
Well, they're in there, but the whole
And
amount was put in a trust.
How many other cases did your client have where he put his fees from a personal injury settlement into an irrevocable?
Just respectfully, Your Honor, that's not in the record, and I don't know if it was in the record. Yeah, I don't know what one way or the other. But
Counsel, weren't everything you're arguing to us, that was argued to the trial court, correct?
yes, it was. But the trial judge made a mistake of finding that this establishes beyond a reasonable doubt criminal intent, and there are several reasons why a reasonable doubt is present in the record.
But she didn't find him credible. Isn't that a credibility determination that the trial judge made?
We have testimony from other witnesses. We have the defense attorney from the Williams case said that there was no funds paid, no release signed. We had the Mr. Caggiano, Mr. Koepke's lawyer, who testified that in his opinion there was no settlement because there was no meeting of the minds, there was no court approval.
But there was a signed agreement, and the order said, bring the signed agreement. So I don't think I think that argument has more validity if it said, show us where the funds are, or there was something, and I understand that may not have been completed, but the order seemed pretty clear about what they were asking for after 3 years of litigation over it.
Well, I'll make one more point on that, and that is that the former wife's attorney had received notice of this case, the Williams case, back in 2016 when it was disclosed in discovery. And so that lawyer could have gone and looked through the court file in that case, could have talked to the opposing counsel in that case, who, by the way, as I keep saying, was a witness who said there wasn't a settlement. But the case was disclosed, and so that evidence is the lack of criminal intent to hide this source of this big fee from the future. Mr. Koepke was, he was trying to gain benefit from language, but a contempt order has to be strictly construed and beyond a reasonable doubt, and I think the court really has to follow the other three districts on the lack of personal service of this. It's going to throw the law into disarray if this court says, no, you can email it to the defendant's lawyer and that's good enough, and the other three courts say it's fundamental error not to have personal service. So it asks that the court reverse this, and if it reverses it on the technical ground and not on the other ground, then we'll go back for a new trial, and we'll have a new trial with proper service. And if he's convicted of criminal contempt in that one, and the evidence supports it, we won't be back here again. But the court should reverse.
How old is Mr. Koepke now?
He's at 82.
All right, thank you.
Thank you.
Right.
Morning, Your Honors. I'm Greg Wilson, and I'm 75. And I tried to get this information for an awful long time, and something that wasn't mentioned was that the order of the court was also ordered Mr. Koepke to produce any documents that dealt with settlement. And one of the documents that ultimately was produced after he failed to bring him to court in the trial, and it was mistried and not scheduled again for months, was a document where right off the bat, right after he filed suit, offered them the policy limits way before the mediation. Never produced that. I mean, this was...
Does the record indicate when the monies were actually sent to Mr. Koepke?
I don't know what it should have. And I believe it was, I don't want to cite a bad year for you, Judge. This case is 9 volumes of pleadings over the last so many years, and I've lived with a lot of dates. But he received the money before we found out that the money had been given to him. And the money didn't go directly to him. It was worked out in a deal where the insurance company paid it into a trust, and the trust paid his client a certain amount, and then the trust paid another trust his fee. And before that happened, some of the money was taken out to pay his lawyer, which was, about $100,000. And some money was paid to him, I think about $70,000 to pay taxes. And even to this date, we don't have
I understand that
access
it may be outside of the record, but is Mr. Koepke still significantly behind in his alimony to the former wife?
Oh, yes. In fact, we're back in scheduled, I believe, the end of July for another motion to...
We can't.
I understand. I was just asked the question.
I understand that.
Anyway...
Can you address the service of process? Opposing
best I
counsel
can.
has said fundamental error, all the other districts indicate that.
Well, I don't think the 5th DCA does, and there's no case out there that says it about service. I think there are other districts, and they're back in one's 91, one's 94, and the newest one is 07. And if you go through all those cases, they really don't talk about any facts similar to this, for example. I don't even remember the name.
Hagen was decided in the context of hearsay. I mean, that's the statement in Hagen that talks about fundamental error was the admission of an affidavit from a police officer, which was hearsay, and so I'm not sure precisely what, where we were going with that. And then Graham, of course, just cites to Hagen for that proposition. So should it be fundamental error?
No, sir, Your Honor, certainly not under these circumstances, plus under the law, which has changed. I'm not sure it's clear, but of course we all run into that a lot. But if you read, first of all, if you read the rule itself, it doesn't say anything about formal service of process or how it should be served. In fact, it can be read two ways because it's really can be read to say, let me get a copy of it just so I don't misquote the thing. With a reasonable time allowed for preparation of a defense after service. It's not saying a section, you must serve this order a certain way. It's saying you have to give them time to defend themselves after service. And I'm afraid it got read by these other courts in their opinion to say this means service of process. In my opinion, it means give them due process after service. Doesn't say what kind of service.
You think the fact that he was served through the portal, does that make a difference?
Well, I've researched that, Judge, and I think that the portal, if you read that, it starts out by saying, unless the court otherwise orders. That's the first 5 words of telling you what to do. And in this case, what the court did was otherwise order. The court could have arrested him and brought him in. He wasn't going to do that. He was co-counsel. He not only knew about it, we had filed a motion to have an order entered. They had filed a motion to respond. The court entered an order in a hearing allowing them to respond. They didn't respond. They gave a memorandum, not a response. I gave a memorandum in reply. There was an arraignment date where KARL KOEPKE was there, all this in the record, and they asked for an amendment to that order because it was unclear as to whether they were going under the 03 direct or the indirect 04, and the judge entered an amended order. They answered, they moved for bill of particulars, they had motions to dismiss, they had a criminal lawyer, got paid a lot of money. I haven't gotten paid for years. And, well, I take that back, I got a couple $1,000s in the judge's order recently. And that's not neither here nor there, but it's certainly, they had every kind of notice, and he was an attorney of record. He got served with the document any way you want to slice it, because the court didn't want to do it by arrest. The court wrote an excellent order saying that he covered every base for due process. He cited the cases for it. He cited all the facts that he came up with his decision. What we haven't talked about either is he was subpoenaed to come to court with his file. Didn't say you had to bring certain document or anything else, bring his file. He didn't even do that. We had a 2 or 3 hour delay before the court ordered him to go get his his file, and the case got mistried because the court couldn't go on the following day and try the case. And we didn't try it for months after that. I don't remember the exact time. And it was a new judge. We've had a big problem with judges, which was exacerbated by, I don't know who exacerbated this more, but probably Mr. KOEPKE. But let me tell you one thing that you were asking a question on that I can answer. If I remember what I was going to say.
Is this going to happen to us when we hit 75?
It's happened to me all my life. See, I've always told my wife that I could never remember names, so I have a fallback here. No, and if you ask me, I'll tell you. It doesn't make that, it was somewhat minor, but, I know how I found out about it. This case was not ever given to us by case name, just that he had a personal injury case with, I don't remember what it said, back injuries or what kind of injuries it was. I tried and tried and tried to find out something and looked it up on the I don't know whether you want to hear this because it's outside the record. No, it is part of the record. I testified to it. And found the name and called the lawyer who represented the insurance company. This is all part of my testimony. Called the lawyer who represented the insurance company. I said, is there a mediation settlement agreement? He said, yes. I told his lawyer, KARL KOEPKE's lawyer, at a deposition, exactly what I just said here, and went back in and he denied it.
Counsel, they are saying that there was no intent proven beyond a reasonable doubt. Do you think that the trial judge was weighing the credibility of the other version of events? Or what do you think? Why did the trial judge rule that there was an intent? What do you think was the specific thing?
Well, because there was two things he didn't do. One was answer discovery properly by saying there were no such documents, and two, by bringing the file to court when we did go ultimately after ordered to, but didn't bring it initially, and those documents were there. Whether that is a contract, it says it is. Agreement means a contract, but the judge argued himself on that. He says it's like a contract where you buy a house. You enter into a sales agreement, and you're bound by it, but there's conditions to it. You're not going to argue successfully to anybody who knows anything about the law that you didn't enter into a contract to purchase an agreement. In fact, there probably isn't a contract on earth that doesn't have conditions. I mean, they at least have a condition of payment, and when there's payment, but it's a contract. And that was bogus, and his lawyer never even asked him about those documents. He testified in the hearing, the criminal hearing, his lawyer did, and said all I asked him was whether there was anything in the file that would answer the question. And I begged him to go look at the file. That was the lawyer. He wouldn't go look at the file to find the documents. I said, call the other lawyer, and who, he'll tell you the documents. Or he wouldn't do that either. Maybe that's more of a grievance matter than it is for this court, but it certainly shows every bit of intent. Heck, I even went to the hearing in front of the circuit judge to try and find the document, and I testified to all this, and they excluded me because of the privacy issue of the children. And I asked the lawyer the next day, I'll testify to this for the insurance company, and he said KARL KOEPKE gave the judge the mediation settlement agreement because his copy you couldn't read. And they were still denying it existed. And he didn't file any motions for protective order. He didn't say, I don't understand. He didn't say, Judge, let's have an in-camera hearing on this and let you determine whether this fits within the category.
And you think that's why the judge found that there was criminal intent, there was an intent element there, as opposed to...
Well, if you're asking my opinion, over the years, I've done a little bit of criminal work. If I couldn't convict somebody in front of a jury on those facts, then I'm not worth my salt, if that answers your question. So, yes. That's all I have, unless you have a question on it.
Thank you.
Thank you, Your Honors.
Going back to the fundamental error issue, the council argued that a client went to the hearing, he didn't raise it at the time. This is just like the Giles case where there was an order to show cause. Giles had actual notice, and he went to the first hearing. He pleaded not guilty, and he requested an evidentiary hearing. He didn't say, "Hey, you didn't serve me notice." Then there was a second order to show cause, and there the court held Giles was not served with a new order or amended petition. Not served. Now his lawyer, who was counsel of record, was provided the thing by facsimile, just like he did now before the email under Rule now what 2.516. So that was service. If it was service of a motion or order or something other than the initial pleading, that would have been good enough. There was no objection to that, and he went to the evidentiary hearing based on the new order to show cause, and the court held it was fundamental error to adjudicate him in criminal contempt of court. That case is squarely on all fours with this one. It cites the First District case, which also used the term fundamental error. Says no statutory authority under the rules of civil procedure for serving only by certified mail. As that's the rule 2.516 and the old rule 1.070 for service. That's service of stuff beyond the initial pleading, as we cited in our reply brief.
Now, the language of the rule itself doesn't set out how it has to be served, does it?
No, it does not. And the courts that have decided that it's fundamental error not to give personal service have noted that it doesn't say. But they recognize this is the initial pleading in a criminal case. You've got to conduct the formalities of formal service, and it's fundamental error not to do it. And the court should reverse the adjudication. Thank you.
Counsel, if we were to give you the relief you're requesting, do you believe this court has the authority to condition the retrial on your client posting the full amount of past due alimony in the court registry?
I don't think you. I don't know how you could do that without a finding of his ability to access the funds and ability to do that. I think.
I trust, pun intended, he could find the financial resources for that. But as a blanket matter, do you any authority one way or the other that we have the ability to do that?
I don't know of any. My knowledge of requirements of bonds just prevent execution. They don't prevent you going forward and seeking the relief in the court. You're not foreclosed from appealing or trying a case because you don't post a bond, except in an injunction situation. I don't believe so, Your Honor. Please reverse the decision.
Thank you, sir.
All right, thank you.
Thank you.